Resident lawyer Despina Prialo from boutique law firm Prialo Legal in Runaway Bay with us each and every Thursday morning. At this time, she brings her legal expertise and provides some general advice on the latest of hot topics. She has experience that spans more than a quarter of a century in the area of property and commercial law. She prepares wills as part of estate planning and litigation. With us once again, hi Despina.
Good morning, Wayne. Good morning, Brooke.
Good morning, Despina. Good morning, Wayno. So, obviously, many people across the coast and Tweed are planning or in the process of building at the moment. But unfortunately, the 13th largest home builder did go bust earlier this year, Porter Davis. And Despina, you think that this isn't going to be the last?
No, not at all. So I've got a very interesting segment that we want to talk about this morning about build contracts again. But I thought now that it's been reported of the amount of money that's being owed by Porter Davis, and I thought that we would mention that first to put it in perspective about what's happening in this country and what's happening with the collapse of builders that have been occurring for the last 12 to 18 months and the ripple down effect that it is having and it continues to have on the economy and the construction industry. I thought we'd just mention a few facts about what's been reported on Porter Davis to then lead into a very interesting topic about build contracts and a recent case in the District Court in Queensland, which everybody will want to listen up to. So what's been reported with Porter Davis, and if you remember, Porter Davis collapsed earlier this year. Now, Porter Davis, as you said before, was Australia's 13th largest home builder that went bust. Okay, and they were predominantly in Victoria, but also they were building in Queensland. Now, that was reported they had 1,700 projects and they have 779 empty blocks of land sitting there. That's what was left. And it's reported that they owe, at this point anyway, $147 million to creditors.
Awful.
It's frightening. And to think of that a lot of those creditors are unsecured and most of those that are going to miss out are the tradies. And it's very, very sad. And this will and does have a ripple down effect in the construction industry. And I believe next month, right, I won't say any more other than I believe there's going to be more builders collapsing coming up in a few weeks, just from what I've read and what I can see on various websites myself in my own research. So it's going to continue, and I don't really know what the answer is. But what I want to do is help consumers who are in build contracts right now, okay? Because now more than ever, it is so important to get advice on your build contract. Now more than ever. And I can't stress that enough. I mean, it's hitting the headlines. Everybody knows that the collapse of builders has occurred, and it's been so prevalent in our society in Australia that you really have to wake up and say, hey, I'm not going to sign this build contract until someone vets it and someone that understands build contracts. And it's for your protection. And the reason why I say this is a recent case in the District Court. It was between Perera and Bold Properties Queensland. And why it's so important to get advice is because this particular case was about, obviously, a dispute between a consumer and a builder, where the builder tried to unilaterally increase the build price that was already fixed in the contract, right, using its own discretion to do so. And that particular provision that was in the contract, right, was found to be void and unenforceable, which means the builder was never able to actually do what he wanted to do because it was simply in the build contract. Because it was in there, the builder said, well, I have a right to enforce this clause. And the court disagreed and said, actually, you don't, because the clause itself is found to be void for uncertainty, and it was found to be an unfair contract term. And that's pretty significant when you think about it, because in my view, I'm thinking, how many build contracts are out there where they may contain a similar clause, which I'm going to read in a minute, and other provisions that might be deemed to be void because they're simply uncertain. But even if they're not, what if they're just simply unfair under the Australian consumer law? And this is all about protecting consumers, people who sign build contracts, right? Whether they already own the land or not, doesn't matter. They're a consumer who have signed up with a builder. And because of the way the market is, I'm just saying that you really have to take extra care because of the escalation of construction costs, where builders might try and do things that they're not really allowed to do.
Yeah. And this particular builder involved in the court case, is he Queensland based?
Yes.
Queensland. Yeah.
Yes.
So
Yes.
local. Mm.
Yes, yeah, absolutely. So there was a special condition in this build contract, and let's put it into even more perspective. Let's go back. Let's talk about what the fixed price was. So it was $645,370. That was the fixed build price to build a home. Now, there was a special condition in the contract inserted, right? And it said that the builder reserves the right at the builder's sole discretion, right, to increase the contract price to current base price of house type to builder's current base price for that house type. Does that even make sense?
No. You lost me after the second line. So that
Exactly.
was the words in the contract.
That was the special condition included in the contract. A lot of gobbledygook, so it doesn't make sense. And the district court said so.
Yep.
Wow.
Yeah. And it was void for uncertainty. And the reason, there's a few reasons, but the main reason is that if you're going to put a condition in that says, well, we can unilaterally increase the contract price, let's put aside the fact that that's really an unfair contract term, because you're only having one party decide the fate in the outcome with no rights to the other party, which is fundamental to saying something is unfair contract term under the Australian consumer law. Putting aside that, there was no criterion, there was no method, there was no formula set out to say, well, this is how we're going to increase the contract price. It just said we can do it, but how are you going to do it? And you're referring to some current base price of a house type. What does that even mean? Again, facts only known to the builder. So if there was a formula put in, if there was a formula that was logical, that was understood, the outcome probably would have been different. You see?
Yep. So you talk about this term being in the contract. Obviously, the person signed at the bottom and said, "Yeah, okay, that's fine. I'll go with that." Would you suggest that this contract perhaps wasn't checked by a lawyer before the person signed it? I mean, surely if it had been checked by a lawyer, they would have said, "Ooh, no, there's a problem here."
Possibly. I suspect it wasn't checked. A lot of consumers I know don't get their build contracts checked because they come to me after they've signed it to try and fix a problem. So I know
you rip your hair out going, why didn't you come to me earlier?
Yeah, I know. How many times do I say get advice before you sign? And when you're spending, here's a $645,000 build price, why don't you spend, I mean, what's the legal fee? It's not even going to be 1%. I mean, really, or 2%. Why don't you spend the money to get that advice? And you actually can negotiate. And this is a misunderstanding, I think, in with consumers generally. Well, the builder's the builder. He's been around for so many years.
Yeah.
I can't negotiate the terms of my build contract. Not at all. I don't have that ability to. Absolutely you do. And the Australian consumer law says that you can, because something that's in your contract which doesn't allow you to have any rights to counteract something that is given to only one party to determine on their own unilaterally is unfair. And if that's the case, what are your rights as a consumer? So in this contract in particular, what the court said is that also we're talking about unfair contract terms where you've got the clause giving a benefit to one party only, where that party has the sole right to enforce it, right? And the actual consumer doesn't have any rights. For example, okay, well, if the builder's going to increase it under this umbrella of, well, increase the price, how, what, where, when, then do I have a right to terminate? Do I have a right to renegotiate the price? That wasn't even in the contract either. And that was very important to the judge at the time that was deciding this particular case.
Yeah, so it sounds again like, and we've talked about this before, perhaps we're just a little too trusting sometimes.
Well, yes, it's that. And it's also the fact that, as I said before, I think there's a big misunderstanding that you don't have the ability to negotiate your price. Okay, you do. You absolutely do. And I want to get that message brought home to people listening out there. This is all about consumer protection. And the consumer protection laws are there to be used where they're required to. And in this particular case, not only was the clause deemed to be uncertain, therefore void, because who can decipher what that clause meant, and the fact, which I haven't mentioned yet, that it should have been on the front page of the warning statement that appears on your bill contract, which it didn't. So clauses like that.
It was down in the fine print there somewhere.
It was on a separate
page 27.
page.
Yeah.
Yes, it was on a separate page somewhere else where it could easily have been missed by the consumer. So the QBCC Act says, no, you've got to put it prominently, I should say, on the front page. The builder didn't do that. So that was, a non-compliance tick as well. So even all of that, you've got something that's unfair because, as I said, it's a significant imbalance between the parties. It's not actually necessary to protect the builder's interests entirely, and it's going to cause a detriment to that consumer. So therefore, you've got all the principles underlying what's an unfair contract term under the Australian consumer law. So yes, the message very much should be, don't sign your bill contract till you get it checked. If you happen to be under a bill contract and you didn't get it checked, or even if you did, and the builder at some point in time, or maybe already has, tried to increase that build price, you want to look at that clause and say, well, how are you trying to do that? And what clause are you referring to? Because it might actually be void.
Very handy advice. Thank you so much again, Despina. And coming up next, imagine paying thousands for your dream cruise through Europe along the waterways. But in reality, instead, you end up forced onto a bus. Oh, man, hopping between hotel to hotel. This is an unbelievable court case, and it's coming.
Are you confused about legal jargon? Do you need legal advice but don't know where to turn? Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97. Despina, a leading lawyer with over 20 years of experience, will demystify the law and provide practical advice to help you navigate legal issues. Whether it's a family matter, a property dispute, or a business concern, Talking Law has got you covered. Don't miss out on this valuable resource. Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97.